Good day, everyone. Thank you so much for logging in to listen to our presentation, Best Legal Practices in Owning and Operating Rental Property. In this presentation, we are going to discuss non-payment of rent, which is the N4 notice to end tenancy for non-payment of rent, and evictions. My name is Bita Delisi. I'm a licensed paralegal with Stonegate Legal Services. If you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram. We're always giving away our materials and always keeping you updated with what's going on in the realm of landlord and tenancy matters. On the bottom left corner, there's a scan where it says scan me. There's a QR code. If you use your smartphone, you can add us directly as a contact to your contact list. I recommend that you check out our website, stonegatelegalservices.ca. If you ever have a tenancy matter that you require clarity on, or you have a question, or you just want to run something by us, feel free to send us an email, info@stonegatelegalservices.ca. It's the best way to get a hold of us. Let's get started. So, a brief introduction about myself. My path started in real estate. Through that path, I started a property management company alongside my husband, Rob, which we, managed small apartment buildings, medium-sized apartment buildings, commercial plazas, schools, and churches all across the GTA. And then when I went back to school to obtain my paralegal license, our real estate business just shifted. And now all our firm does is that we provide legal support to realtors, landlords, and investors. For the purpose of this presentation, everything that we discuss is for information only. If you have a question regarding a legal matter, or if you require clarity on a matter that you're going through or you're experiencing, feel free to get a hold of us. So let's talk about, did your tenant pay the rent this month? Today is the first of the month, and let's talk about if you got paid. Rent is considered late if it is paid the day after it's due. I never recommend that you should wait until the tenant doesn't pay for X amount of time. I always recommend that you should start the non-payment of rent process immediately. Let's talk about errors, because we're going to discuss errors back and forth throughout this presentation. The N4 must be free from any and all errors, no matter how minor, as they can make that notice defective and invalid. So for those newer landlords, here is what the N4 notice for non-payment of rent looks like. The screenshot on the left is the first page of the N4. The screenshot on the right is the second page of the N4. We're going to dissect the N4 throughout this presentation. Let's talk about parties to the notice. So when you're listing tenants, all names of the tenants must be identified on the N4 as they are identified in your lease agreement. So don't leave out a tenant. In cases of verbal tenancies, we do understand that sometimes a lease agreement doesn't exist. You must include names of only those parties that have been paying the rent. If your tenant uses a nickname, use both their legal name and their nickname. If you have a joint tenancy, so if there are two or more tenants on a lease agreement, you should make sure to include the names of all parties. And the same applies to landlords. You include the names of the full names or nicknames of all landlords for a rental property. Occupants are not required to be listed on an N4. Occupants are, for example, elderly parents, young children. Basically, these are occupants who live with the tenant, but they don't pay the rent. It is very important for the address of the rental unit to be specified. You must specify exactly the rental unit that's being rented. So where is the tenant living? Is it a main floor? Is it 123 ABC Street? Is it a basement apartment? Is it an upper floor? Is it a unit number? Is it a suite number? Be specific. So what is the N4? The N4 notice is a 14-day termination notice. It gives basically the tenant three options. Option number one, hey, Mr. Tenant, pay in full and you can void and preserve your tenancy. Option number two, Mr. Tenant, you must move out of the rental unit by the date of termination. Or option number three, you can ignore the notice and wait until the landlord files with the landlord and tenant board, which is often the case. The second page of the N4 is the rent arrears calculations. Please pay attention to this slide because this is where 95% of the errors are made. You see the screenshot to at the top of the page is the rent arrears calculation. This is the information that the landlord provides to the board. The rent period, which is on the left side, this is the date of the rent period term. So for example, if the rent is collected on the 1st, the last day of the rental period is on the 30th or 31st. If the rent is due on the 15th, then the last date of the rental period is the 14th. A rental period does not run from the 1st to the 1st. That's an error. That minor error alone will dismiss the application, and you're going to have to start the process over again. So be mindful of this section where the calculations are. Signatures. So let's talk about that. Realtors and property managers cannot serve N4s on behalf of their clients. So who can serve the N4? Who can serve any legal notice? Only the landlord or their legal representative can serve a legal notice. That's it. If there are multiple landlords, only one of them needs to sign the notice. The date next to the signature is a date that the notice must be given or sent to the tenant. If there are multiple tenants, make a photocopy and serve each tenant. You must also keep a copy for your records because that's the copy you're going to be filing with the board. So what else do you need to know about the N4? Okay, the only rent arrears can be listed on the N4. Nothing else. Anything else listed on the N4 will make that notice defective and invalid. You cannot claim unpaid utilities on an N4. Okay, you cannot claim NSF checks on an N4. If you have already served your tenant with an N4 notice and another month becomes due, do not serve a new N4 unless the tenant has paid the money owing on the last one in full by the termination date. So multiple N4s are not required. How can you serve the tenant? Okay, so when I say you, I'm not referring to your realtor, your property manager. It's either the landlord or the landlord's legal representative that can serve and issue notices. That's it. One thing I love about the real estate industry is that the real estate industry has really evolved with technology. And what I mean is that realtors are using their smartphones. You're using, you're scanning documents, you're using e-signature tools to send and sign documents. Well, the wheels of justice spin very slowly. And what that means is that landlords must serve their tenants in accordance to the rules of procedure of the Landlord and Tenant Board. More specifically, a certificate of service must be filed with the N4 notice. The certificate of service says what? The certificate of service is basically proof of service. It states that the landlord may serve their tenants in one of the following ways. Number one, by handing the document to the tenant. Number two, by handing it to another adult in the rental unit. Number three, by placing it in the tenant's mailbox or where mail is usually delivered. Number four, sliding the document under the door or through a mail slot. Number five, faxing it to the tenant's place of business or residence. Or number six, by courier, registered mail, or express post. If the notice is being served via mail, registered mail, express post, basically by any type of mail service, you must add 5 days to the termination date. Again, realtors cannot serve these notices. This is what the certificate of service looks like, because often I get challenging realtors who say, well, how do they know that we served it? Well, by the certificate of service. Right? So this is what the certificate of service looks like. It identifies who was served, the method of service. So as you can see, there's no email or text message as a method of service, and who served the notice at the bottom of the page. It's very, very important. When do you file the N4 and certificate of service with the board? So the N4 can be filed with the board by way of an L1 application to evict the tenant for non-payment of rent and to collect the rent arrears that the tenant owes. This can be done as early as the day after the termination date in the N4. So the N4 certificate of service, the L1 application must be filed with the Landlord and Tenant Board. If the N4 is not filed within 30 days of the termination date, then that notice becomes void automatically. Once filed with the board will then set a date for a hearing. Let's talk about the delays, because pre-COVID, it took an average of about 4 to 5 months to receive a notice of hearing. Well, on March 16, 2020, the board shut down. So they were not holding any in-person hearings with respect to applications that had evictions attached to them, and that included the N4. The board actually resumed operations on August 1st, and they started holding video and telephone hearings for landlord applications. During that period of time, they probably incurred in and around 80,000 applications. 90% of those applications were landlord applications, that including the N4. Currently, the average of time to receive a notice of hearing is about 9 to 12 months. The board is working very efficiently through the backlog. So right now, from my experience, I'm probably getting notice of hearing in and around the 5 or 6 month timeline. So what does a notice of hearing look like? So this is what a notice of hearing looks like, okay? Anyone can attend a hearing, okay? You can attend as a party to a notice, or you can attend as an observer. You must attend your hearing. If you don't attend your hearing, or if you don't send a legal representative, your hearing will go on without you. Parties are encouraged to work together to put together a repayment plan for the arrears. Please keep in mind that you're not going to receive an immediate eviction order unless your tenant doesn't show up to contest the application. Okay, parties are encouraged to put together a repayment plan and work together in order to keep the tenant in the property. So, can a tenant make excuses for reasons why they haven't paid their rent? Absolutely. We refer to these as Section 82. These are issues that a tenant can raise at a non-payment of rent hearing. Okay, Section 82 is a section in the Residential Tenancies Act where it allows a tenant to basically raise other issues on an application involving arrears of rent that they would have raised had they filed their own application, such as maintenance concerns, illegal charges. This is often viewed as a delay tactic. This is the part of, this is a notice that also gets sent out with your notice of hearing. And this basically allows the tenant to describe the issues that they want to rely on at the hearing. This is the Section 82 issues that they can rely on. So at the hearing, what happens? So you receive an order, usually about 30 days after the hearing. The original copy of the order can be filed with the enforcement office, which is the sheriff's office, to book a date for an eviction per the date included in the order, only if there's a breach of the order. Tenants, you have to understand this, because tenants can bring a motion, and a motion is basically you're requesting the boards or the courts to do something. Tenants can bring a motion to set aside an order, basically to put a hold or a stay for any reason, for because they couldn't attend the hearing, because they feel that the adjudicator, there was an error, some sort of an error. This is also viewed as a delay tactic. So what happens on the day of the hearing? On the day of the hearing, on the day of the eviction, not the hearing. On the day of the eviction, the sheriff arrives to evict the tenant. The picture on the left is the picture of the uniform of the sheriff. So you can see it says enforcement officer. The sheriff is not a police officer, okay? The police officers do not have the authority to evict a tenant. Then a notice of vacant possession is posted to the door, which is the notice on the right side of the screen. Then vacant possession is given to the landlord and locks are changed on the spot. So you're probably thinking, well, if the tenant was evicted, what happens to their belongings? I call this the 72-hour rule. This is the aftermath. The landlord must provide the tenant access to the property for 72 hours in order for the tenant to remove their belongings. After the 72-hour period, the landlord can then dispose, keep, or sell any belongings left behind. So if the tenant owes thousands of dollars, if they are working, how can you collect the arrears, the monies that are owed to you? By way of garnishment. So you can collect them by way of garnishing their wages or the bank account through the small claims court. We're coming close to the end of the presentation. This is the Landlord Mastery. We never charge for any of our giveaways. This is a guide that my husband Rob and I have put together. It gives you access to a Google Drive where you can access scripts, forms like the Ontario Standard Lease Agreement, other agreements like the parking agreement or air conditioning agreement, and notice of entry. Basically, it's a guide to assist you or your clients on how to own and operate their rental property. We're at the end of the presentation. I'd like to thank you for listening. If you have any questions, feel free to shoot us an email, info@stonegatelegalservices.ca. Immediately head over to our social media, like us, follow us on Instagram and Facebook, scan that QR code at the bottom left corner of the slide so you can add us in as a contact. And if you ever have any questions, feel free to get a hold of us. Until next time, bye for now.